a lot of food for thought from all the data that you have presented, and also taking note of interdiscipline and scholarship in insolvency law. And we hope to be able to achieve that with the starting point of the first paper that we're going to discuss today and the three others that we're going to discuss tomorrow. An attempt has been to actually look at practice insights, look at numbers perhaps, and have that discussion on the table, because oftentimes you do not have a policy or an academic response looking at practice closely and vice versa. That's also the motive with which the Insolvency Law Working Paper Series has been put together. And I'm very grateful that we have a comprehensive participation and an all-encompassing participation as a part of all the panels that we're going to see, starting with today and, of course, the panels for tomorrow. Now, incredibly important aspect of the lending market and the credit churning market has been the nature in which credit is provided, from unsecured lending and moving on to secured lending, particularly because of the manner in which you can recover as a part of insolvency and its general economic impact. That's also the theme of our first paper that is being presented on secured creditor rights under Indian insolvency law. Now, this piece has been authored by Suharsh Sinha from AZB Partners, along with Sagar Shankar and Untitled from Red Intelligence, and therefore bringing to the table a policy and a practice perspective together. For those of you who have not been able to download this paper or have not had an opportunity to look at the paper yet as a part of the panel, I've shared a link of the papers which you can access and download. Now, one of the things that we need to look at closely and what this entire series seeks to achieve is presentations by practitioners to highlight key issues as a part of the papers that they've written, and get responses and channel discussions like Mahesh has left us with, to allow for further writing, further inspection, and further investigation as an attempt to develop insolvency law work and a lot of material that will allow people to have conversations at a policy level, at a regulatory level, at a legislative level, and also in practice. So without further on what these four papers achieve, which you will be able to understand and look at from the discussions that we have planned, I'd like to introduce the first panel of the JGILS series, which comprises of Suharsh Sinha, who will be presenting the paper, Sagar Shankar, and Ringe, who's also the editorial board member of JGILS, as discussants.
May I start, Ishana?
Yes, just a sec, Suharsh. I'll just check for co-host access. I can please provide co-host access to Suharsh so that he can share the screen. Just a very brief introduction, a one-liner to this particular panel. So instead of the pages, I'm sure we live in a Google generation, so we've looked them up already. Suharsh Sinha, who will be presenting, is a partner at AZB and Partners, a leading law firm, and is a part of their bankruptcy and insolvency practice and their banking and finance practice. Recently, many accolades his way, where he was ranked for restructuring and insolvency by Chambers Asia Pacific, and is also recognized as a notable practitioner for banking and finance restructuring by IFLR 1000. He was also listed as a recommended lawyer by Legal 500 Asia Pacific. Our discussants for today are Professor Dr. Greg Ringe, who is the director of the Institute of Law and Economics at the University of Hamburg and a visiting professor at the University of Oxford Faculty of Law. His research focuses on a broad range of corporate and insolvency law, capital markets, and financial regulation from an interdisciplinary and a comparative perspective. Our second discussant for today is Sagar Shankar, who works as a financial sector expert with the International Finance Cooperation. His work with the IFC primarily focuses on the area of financial infrastructure, where he works on secure transactions, insolvency, and creditor rights reform, and fintech regulation projects with various financial sector regulators. Sagar also consults on financial inclusion and access to finance efforts for MSMEs and individuals in the South Asia region. Now, without saying further, please, Suharsh, over to you to present, followed by a discussion by Sagar and Georg, and then open for discussion to the audience. Thank you, Suharsh.
Thank you, Ishana, and thank you very much to General Global Law School for the opportunity. Ishana has been working tirelessly in this space, and I've had the opportunity of collaborating with her in the past as well. And as usual, it's a pleasure to be on a forum with General. And more importantly, it's a real pleasure to be with such distinguished panelists. My good evening to Sagar and sorry, George, am I pronouncing your name correctly? Is it George? Sure. Also had the opportunity of hearing towards the end of Mahesh's presentation. So thanks for that, Mahesh. I think it was very instructive, especially on the MSME part, because we are struggling in India, as you may be aware, with the MSME bankruptcies, even though we have a new pre-pack regime. Whether it will be accepted and whether it's going to take off or not, I think is still a big question mark. So thank you for your inputs. I couldn't hear your entire presentation, but I was there towards the last few minutes. So thanks for that. So this paper has been co-written by me and my colleagues, Gausia and Urmika. Both of them probably, the brightest lawyers of their generation. We were colleagues together at AZB, and then I think they decided they had enough of me and they quit. And now they are journalists, legal journalists, and they're still doing a lot of interesting work in the insolvency space in India and in Southeast Asia. So without further ado, I'll start with my paper presentation. I've made a few slides, not too many, hopefully. Let me quickly put that up. Apologies. Is my screen visible? I'm just going to. Sorry. Is my screen visible now, Ishana?
No, it isn't.
It isn't? Okay, my apologies. I'm trying to share my screen.
Why don't you drop the PowerPoint to me and I can...
Can I email it to you? Okay, great. Just give me a minute. I'll just email it to you. I'm sorry for the delays. I just sent it to you, Shan. I'm not sure if it's come up. Okay, so I think while Ishana tries to put it up, I'll just start. So what is interesting about the Indian law, and which is, oh, there you go. Thank you, Ishana. So what is interesting about Indian law and is a huge departure from how things are, say in the US or UK or rest of the insolvency world, is that we don't have a distinction between, the axis of distinction is not secured versus unsecured creditors in India. It is actually between financial creditors and operational creditors. That is the axis of differentiation. And that leads to certain unintended consequences, which we are trying to analyze in this paper in the context of secured creditors' rights. So if we can just move on to the next slide. So types of debt under IBC. So debt under IBC is classified into these three buckets: financial debt, operational debt, and other debt. Now, financial debt is defined as debt along with interest, which is disbursed for the time value of money. Very simply put, the idea was that this is debt which is disbursed by banks and bondholders. Operational debt is debt which is owed to contractual and trade counterparties, like your employees or other trade counterparties, and even government. Even tax dues are classified as operational debt. And debt which does not fall into either of these buckets gets into the residuary category, which is other debt. The reason this distinction is important is because once the company goes into IBC or corporate insolvency resolution process, which is the restructuring phase, then the committee of creditors only has financial creditors. It does not have operational creditors. And that distinction becomes even more important when we are looking at voting rights during a resolution process and in liquidation. The policy objective was to prioritize financial debt and the rights of banks as opposed to those of the taxpayer, of the government and of other operational creditors. At that stage, the logic was that India had a very high NPA ratio, and most of the Indian banking sector is public sector banking. So this was, in some sense, it was not only a means of strengthening the rights of banks and secured creditors, but also of shoring up government's own reserves and fiscal issues. If you can go down, please. Now, this is a slide which Ishana and I have worked on in the past also. This, I think, is the crux of the debate. So how do you view rights of creditors in IBC, or frankly, under any insolvency law? On the left-hand side, you treat creditors in a homogeneous manner. Right? So they are, when you're distributing any proceeds to creditors, then do you treat them as a slice of pie or a cake, where it doesn't matter how you slice or dice it, the consistency of the cake will remain the same. And it's only a question of who gets what is the size of the cake. On the right-hand side is the champagne tower, where only when the top glass in the champagne tower gets filled up, then you come to the next stage. Once that second stage is filled up, then you go to the third stage, and so on. And each stage in the champagne tower is a different class of creditors. So whereas when it comes to a slice of pie or a cake, all creditors are bunched up together. They're all treated in a similar manner. Whereas if you look at the champagne tower analogy, each level is a different class of creditors. Now, if you think of the committee of, if you think of the committee of creditors and how they vote, then you need to look at the cake or the pie. Because regardless of whether a financial creditor is secured or unsecured, its voting share is determined purely by its dollar exposure. So you could be a secured creditor with $100 exposure, or you could be an unsecured creditor with $100 exposure. You will both get 50% voting rights, as far as the committee of creditors is concerned and any restructuring decision is concerned. But when it comes to the proceeds of any restructuring, how will a restructuring plan be paid out or shared amongst the various creditors? Then the analogy moves to the right-hand side, which is the champagne tower. So the gentleman whose picture I have in the middle, that is Justice Mukhopadhyay. He was one of the judges of our bankruptcy appellate tribunal. I think the Indian audience would be very well versed, but this is more for probably George and Mahesh. So this gentleman, I think, with all humility, he confused these concepts. So what he said in one of India's landmark bad decisions, if I may say so, said that the proceeds of a resolution should be distributed like a slice of pie or like a cake, as opposed to understanding and respecting the distinction between various classes of creditors. And when I say various classes of creditors, what do I mean? I mean secured versus unsecured on one level, financial versus operational on another level. And at the third level, amongst secured creditors, there could be different levels of security. So you could have a first charge, you could have a second charge, or you could have an exclusive charge. Right? So these are all different buckets and kinds of security. What Justice Mukhopadhyay did in his judgment at the Bankruptcy Appellate Tribunal, which is the NCLAT, he said that you take the resolution amount and you distribute it pro rata on the basis of everybody's exposure, regardless of who's secured or who's unsecured. Right. Now, that led to a very bizarre situation. I think we can go on to the next slide, please. Now, that led to a very bizarre situation because there were secured creditors who felt that had they liquidated the company in question, in this case being SR Steel, which has till date probably been the largest successful insolvency resolution in India. They felt that if they liquidate the company and they could just enforce their collateral security, they would make a higher recovery than if they were to participate in this farce of a resolution. Because in this resolution, their security rights, which are sacrosanct under general Indian law, were being compromised. Therefore, what was the incentive for secured creditors to participate in a successful resolution? They would rather liquidate the company and enforce their security because they would get a higher payout over there. Now, the law, as far as payout is concerned, is set out on this slide. I won't go into too much detail over here, except for the parts highlighted in red. So if you come down on the left-hand side, if you come down to the mandatory contents of a resolution plan, it says that each financial creditor who's dissenting, who is voting against the plan, must get at least its liquidation value, which means that if the company were hypothetically liquidated, how much would that creditor have made? And any resolution plan must give that creditor at least that much, which means that if I'm a secured creditor who feels that, I'm better off in a liquidation because at least I am no longer fettered by the moratorium and I can enforce my security and get a higher payout, that payout must be given to me as part of the resolution plan. And if you want to bind my vote, then you must offer me at least $1 above what is my liquidation value. Otherwise, I have an incentive to vote against the plan. Right? So this is what the law said. The way it was applied by Justice Mukhopadhyay was incorrect because he basically put all the creditors in one bucket, regardless of the security. The second thing to note on this slide is that the liquidation value due to dissenting financial creditors must be paid in priority to approving financial creditors. So before the assenters get paid, the dissenters must be discharged. Right? So this is what the law said. So the law as it stood tried to balance the rights of dissenting creditors while at the same time ensuring that a successful resolution happens. So this was the balancing act which the law, in my view, achieved pretty well. But this judgment, I think, made all of us in the Indian legal fraternity sit up and actually analyze what security interest means. We researched on bankruptcy laws all over the country. We looked at the Untitled Legislative Guide. We looked at the concept of vertical and horizontal equity when it comes to insolvency under English law and US Chapter 11. I think we can move on, please. I'll come back to this slide, but I think we can just move on. Can you move on one more slide, please, Ashana? One more, please. Next one. So the reason I have this triumphant person here on this slide is because this is Justice Nariman of the Supreme Court of India. So if you felt I was leaving you at a cliffhanger, then this is the resolution. So that judgment by Justice Mukhopadhyay was set aside by Justice Nariman at the Supreme Court. And this judgment has enshrined the rights of secured creditors in India. And this judgment, in fact, even led to certain changes in law. So if you can go back up again, Ishana, I'm sorry, I'm making you do this. Just one slide down where we have one. Go down, please. Yeah, just one up. I'm so sorry. This one, yes. So I'm just summarizing what the NCLAT order said, what Justice Mukhopadhyay said. He said that as far as rights of secured creditors are concerned, inter se, he said there is no distinction. You are either secured or unsecured. So all secured were put in one bucket regardless of the security. Secondly, he said that the debt of the guarantors of the company also stands discharged because the main entity has been resolved. So Indian lenders don't typically grant any loans unless they have a personal guarantee from the main shareholders of the company or other group companies. So Justice Mukhopadhyay said, once the debt of the insolvent company is resolved, then the personal guarantors are discharged. For the extent of the haircut, you can't go after them. The next thing he said is that as far as contingent liabilities are concerned, uncrystallized liabilities will continue. So the new bidder will not get a clean slate. Any uncrystallized liabilities or contingent liabilities will be borne at the behest of the new bidder. And lastly, in my view, again, in a brazen act of judicial activism, which I feel finds no place in a commercial court, he said that banks should not be greedy, and banks should be happy to set aside more of a payout to operational creditors, to employees, to the government, to other contractual counterparts. And through this logic, I think the priority of distribution and the sanctity of secured creditors' rights was affected, which thankfully was reversed. So if you go to the next slide, before this judgment could actually be overruled by the Supreme Court, I think the government realized that there were many issues in this judgment, and the government amended the law. So these are the changes that the government made. The government said that as long as the distribution proposed in a resolution plan is in accordance with the liquidation waterfall, it will be treated to be fair and equitable. So in liquidation, if an operational creditor gets a nil payout because they are subordinated in the liquidation waterfall, and unsecured creditors also get a lower payout because they are subordinated, as long as that is being mirrored in a resolution scenario, then that is kosher, and that should be upheld as legally valid. Next, the Supreme Court, the amended law also said that the manner in which the proceeds of a liquidation or the proceeds of a resolution plan or restructuring plan are distributed amongst the various creditors is a matter of commercial wisdom, right? So let the committee of creditors, let the lenders commercially decide what makes sense. There is very little scope for judicial intervention in it. And a judge cannot supplant his or her own subjective notion of what is fair and equitable, but they should let the lenders decide. And lastly, it also clarified that government dues, which is tax dues, though it was amply clear, government introduced another amendment to say that government dues and tax dues are also covered under a resolution plan, under Section 31 of the IBC, which says that a resolution plan approved by the Committee of Creditors and the Bankruptcy Court is binding on everybody. So these were the amendments introduced by the IBC amendment in 2019. These amendments were then challenged by the Supreme Court, in the Supreme Court. I'm sorry. And if you can go down. And Justice Nariman had to then not only look at the constitutionality of these changes to law, but also the correctness of NCLAT's decision in SR, which was passed by Justice Mukhopadhyay. So the good news is that he upheld the constitutionality of the amendments. He upheld that distribution of proceeds is a commercial matter and it's not something which the judges should interfere in. He introduced fetters on the amount of discretion the judges can use in a resolution scenario. And he also said that there's a presumption of constitutionality. The moment there is an economic legislation, there's a presumption of constitutionality as opposed to, say, a legislation which may affect fundamental rights or human rights, where the level of scrutiny may be heightened. If we go on to the next slide. Next slide, please. So that's where SR ended. Now, I've moved on to another concept, because I think there has been a slight erosion of what was upheld in the SR judgment. because SR said that the value of security and the nature of collateral matters when you're classifying the payout of various creditors. But a few months back, there was another judgment in the Supreme Court, India Resurgence versus Amit Metallic. Sorry, I haven't got the name of the judgment on the slide. But unfortunately, there is one element of SR which has been eroded by the latest Supreme Court judgment. Now, what you see on the screen looks very intuitive, right? So on the left-hand side, you have a bank which is given a debt of 100. And the value of the security the bank has is this AAA rated plant and machinery, great steel plant, right? Which is worth $100. So the debt is 100, the collateral is also worth 100. On the second hand, you have a lender who's given 100, but has security over this rickety shed, which is worth nothing. So technically they're both secured. But are they secured? And how secured are they? So this issue came up in the judgment I was talking about. And Supreme Court said that if you're asking for your liquidation value, so let's assume the first lender over here who has the security over plant and machinery said that I'm dissenting from the plan and I want my liquidation value. So technically, his or her liquidation value is 100 because that is the value of its security. Supreme Court said no, you cannot be allowed to profit because of your superior security. Your security will be pooled in with the other security holders and you will get a proportionate payout. So I think we had a couple of years of bliss after the SR judgment, but this judgment has eroded a very important finding of the SR order. And now I think to some extent, the learnings of SR have been compromised. And I hope that there's a change of law on this front sooner than later. If you can go down, please. So there's a lot that we've covered in our paper. Sorry, in the interest of time, I'm going to rush through now. The other aspect we've looked at is inter-creditor rights. So under inter-creditor agreements, there can be two sorts of restrictions. One is restrictions on statutory rights. And the second is on voting arrangements and priority. So looking at statutory rights, so is it possible for an inter-creditor agreement to basically specify that the junior creditor cannot initiate insolvency without the senior's consent? So there is conflicting case law on this. There are cases which are there before the IBC came into play in 2016, and there are cases since then. I think the common thread amongst them is that statutory rights of creditors cannot be taken away by inter-creditor agreements. So we also tried to do some research on US law, and I find that under US law as well, there is a balance between the public policy objective of not restraining statutory rights, but at the same time respecting the commercial bargaining power of sophisticated parties. Right. So I think in India as well as the US, I'm not sure if we have reached conclusion on this, but I think it suffices to say that in India there is, as long as the restriction is being exercised or enforced amongst creditors inter se, bankruptcy courts. My apologies. Bankruptcy courts are maybe more respectful of it. But if it's a borrower who's saying that a particular lender has initiated IBC or insolvency against me without taking the consent of other creditors, then bankruptcy courts will not respect it because this is a creditor right as opposed to a borrower entitlement. Secondly, when it comes to voting arrangements, on voting arrangements also, the courts have taken a view that your right to vote in a creditors committee is a statutory right. And you cannot put fetters to that right contractually. Right? You may subordinate your payout because that's a commercial call, but not being entitled to vote, you cannot sign away your voting rights. And this is again something which I found that there were a thread of cases under US law. In Indian law, I think this is still up for debate. And the last point is priority, which I think we just discussed in the previous slide. You can go down. Now, I'll end with this. I think I've taken a lot of time. Now, this is, again, a very unique issue which has arisen because of the nature of financial debt. Right? So just look at these two scenarios. Scenario A is that a bank has given a loan to a parent company. A guarantee for that loan has been given by the subsidiary, and the subsidiary goes into insolvency. As per the definition of financial debt, a guarantee in respect of a financial debt is also financial debt. Okay, so I'll repeat. A guarantee in respect of a financial debt is also a financial debt. Therefore, the bank is a financial creditor vis-a-vis the subsidiary because the subsidiary has guaranteed the loan. So this is simple, no issues. The complication arises in scenario B. In scenario B, the bank has given a loan to the parent company, but the subsidiary has not given a guarantee, but has given a mortgage or a security interest over its property. So the bank is secured vis-a-vis the subsidiary, but if the subsidiary goes into insolvency, as per the latest judgment of the Supreme Court, the bank will not be able to sit on the committee of creditors of the subsidiary because it is not technically a guarantee. It is a security interest. Now, there is a difference between a guarantee and security interest. I think all finance lawyers will appreciate that. Because a guarantee is a right in persona. You have a right against the person, whereas a security interest is a right in rem on that specific piece of property. But in my view, in insolvency situation, this is a very fine distinction to make. And you're effectively prejudicing the rights of secured creditors just because the mortgage does not have a guarantee clause, right? There are many mortgage agreements out there which may have a covenant to pay to make it akin to a guarantee. So it's become a bit of a lottery at the moment. So some guarantee agreements or security agreements have a covenant to pay. Therefore, you can say it is not merely a right in rem, it's also a right in personam, and some don't. So this is a troubling aspect of law at the moment. And I think there's scope for reform over there. We have any more slides?
Oh,
so I'll quickly conclude. I think the conclusion that we have drawn in our paper is that there has been a substantial improvement in the rights of secured creditors in India. India is a distinct market from other jurisdictions because the axis of distinction is not secure versus unsecured. It's operational versus financial, right? For several policy reasons. And that leads to its own set of challenges and unintended consequences, which to a great extent have been addressed by the Supreme Court in the SR judgment, except for this, that remaining, that issue of secured creditors inter se. That issue is still, I think, troubling. And that's something which hopefully will be resolved sooner than later. And the last aspect which I find troubling in relation to creditors' rights in India is the whole concept of secured creditor if you're a mortgagee of a company in bankruptcy. That I think there's a scope for reform. So I'll stop there. I'm conscious I've taken much longer than I had promised to. My apologies.
Thank you for that presentation, Suharsh. And for those of you who want to read in detail what Suharsh has just presented, you can obviously download the paper that Suharsh have written. But let's move on to the meat of the conversation, which is to hear from our discussants who will basically respond to the paper that Suharsh Gosia and have written. And let's start with an international perspective. And Georg, over to you.
Thank you so much, Ishana. Thanks for the opportunity to comment on this paper, but mostly many congratulations on this entire project of launching this series. For those of you in the audience who don't know, Ishana is my former student, and that makes it a particular pleasure to see your former students going into academia and launching projects that are exciting. So I'm very excited to be here and also to contribute to this launch event. So what I thought in a couple of minutes is to give you a bit of a sort of high-fly perspective on secured credits. I learned a lot about Indian insolvency law, but you're all far too experienced on this, so I cannot tell you anything about that. It's your job to tell me, to teach me about this. But I give you my sort of European slash international 2 cents on the subject. So the starting point is very simple, as everybody in the audience knows. Secured credit is basically nothing else than a deviation from the basic law of insolvency, namely the pari passu law, right? So that all creditors rank equal. That's the starting point. And that's the key idea of insolvency, that we do not want to give preference to anybody as a starting point, because we want to avoid that dreadful race that insolvency is really trying to avoid. And pari passu has been around for centuries. Since the 16th century in English law, for example, it's been recognized. And over the centuries, I think it's interesting to trace the development to see an almost exponential growth of ownership, which has been very creative, and lawyers and judges have been very creative in creating new types of ownership that basically gave creditors special rights that puts them ahead of the big crowd of insolvency creditors, and gives them property rights in things of the debtor or security interests, as we have just seen. So just think of, I mean, we take all of this for granted now, but think of the inventions, legal innovations like non-possessory security interests. So you don't need to have possession of the thing as a creditor. And then next step, you can even have an interest in future property. You can even have a global security on things. And then I think the intellectual, how should I say, the peak of sophistication is then the creation, for example, in English law, of the floating charge, which most people will know, right, as the most incredible security, I think, that has been created by very sophisticated lawyers, as being so flexible as applying to anything that the debtor will have in the future. And all of this somehow is bad news for the body of unsecured creditors, right? Because as we give more power to secured creditors, the size of the pie that we saw in Suharsh picture is obviously shrinking, right? The more we give to those who are secured, we take away from the unsecured. And so that leaves the question of, is it justified to give them this right of taking security, taking preference? Well, there are lots of good legal reasons. The lawyers will always advance 2 reasons. One is, ownership is ownership, and our legal system must recognize ownership, because otherwise there is no difference between property and an obligation under private law. That would become blurred, the distinction between the two. And if we undermine security interests, that would basically turn things upside down. It would use the very event against which they are designed to turn around and turn it against them. So this is the standard legal reasoning that you would advance in favor of them. Let's think a bit about the economic justification for allowing security. Right? The main story is one of a transaction cost argument that's been advanced. So there is a long debate in law and economics on this, and we've heard earlier in the keynote speech how important interdisciplinary research is on this. So the key justification is advanced by Jackson and Cronman already in the 1970s, who say in the Yale Law Journal that if the law denied debtors the power to prefer some creditors over others, then a similar network of priority relationships could be expected to emerge by agreements between creditors, right? So basically the creditors would negotiate amongst themselves and try to put themselves ahead of the others. And the argument then is that we allow debtors to encumber their assets, which achieves the same result, but is simply a shortcut, is a simpler and more economical fashion. If a debtor has more than 2 or 3 creditors, free ride and holder difficulties are likely to plague any attempt of the part of creditors to work out, right? So there would always be holdouts against a contractual solution. And so all of those transaction costs can be avoided by allowing security interests, basically. So they allow the debtor to prefer one creditor over the other. And the rule permitting debtors to encumber the assets by private arrangement is therefore justifiable as a cost-saving device, so far as a sort of starting point. So the argument here is that we would offer a shortcut over the hypothetical bargaining between creditors by allowing a collective procedure and therefore facilitate the advancement of creditors, which basically is a version of the old law and economics idea of the Coase theorem. So we as a lawmaker, as legislature, we need to facilitate those things that the players would normally reach by agreement anyhow, right? So the obligation of the law is to mimic what private ordering would have achieved anyhow. And that's the key idea of advancing security in insolvency. Now, still, security has its downsides, right? So we've seen on the positive side, yes, it is great because it's private ordering, it mitigates problem from information asymmetries and facilitates provision of debt finance, but there may be negative sides to it. One argument that can be advanced against it is the redistribution problem. We could understand secured credit as a sort of a redistribution of wealth from those who are unable to adjust the terms on which they advance credit. So that's what I said earlier, the pie becomes smaller. And for example, those who cannot negotiate, in particular tort creditors, they are not able to take any security, right? So their pie is shrinking the stronger we make the secured creditors. And related to this is an efficiency argument, which is problematic because we might expect a deadweight loss if there is an excessive grant of secured creditors. A secured credit is happening in order to bring about such redistribution. So there is a shadow of doubt over the justification of allowing secured credit from a non-economics perspective. So scholars have debated then over decades, right? Which now is the right one, which is the right balance to strike, and which is the argument that we should believe in, right? So there is some empirical evidence, and the redistribution hypothesis has been rejected by empirical research. So it's research that has, Lewis Tokin in 2008 has looked into the US tobacco industry, which you think would have plenty of tort victims, right? The involuntary ones. And they don't use a lot of security interests. Right? So that is against the idea of that redistribution is really a problem. And also an interesting other paper shows that secured loans are associated with high interest rates are no lower than for unsecured loans, right? Davidenko and Franks in 2008 looking at European banks. So all of this cast doubt somehow over those theoretical claims that have been made. So which then is then the real justification of why we see secured credit? Well, the main theory that has emerged over time is that secured credit is an instrument to show bonding to the creditors, or put more technically, to reduce agency costs, financial agency costs between the debtor and the creditor. If you give security to a creditor, then it prevents you as a debtor from engaging in anything that might be very harmful to the creditor's interests. So for example, in the famous zone just before insolvency, you, as we know, you as a shareholder have an incentive to gamble, right? Because you have nothing more to lose. You typically put the assets of the company into very risky projects. And if that is sort of secure, that debt, and the asset cannot be gambled for, that would be preventing you from using those assets for gambling purposes. So in other words, security is a bond by the debtor that promised to the creditor, I will not engage in any wealth-reducing transactions. And that is also good for the debtor because it binds the debtor itself. It ties your hand as a debtor You can credibly promise to the creditor that you will not engage in those harmful transactions, and that will reduce the cost of credit ex ante, right? So it's advantageous for you as a debtor in the first place. So in a way, it's similar to covenants, that you promise something to the creditors, but it's self-enforcing, and therefore it has a number of advantages over the covenants that are just contractual promises. So there is some evidence, but there is scarce evidence on that bonding hypothesis. There is some studies that show that security is used by those firms which are riskiest. So in startups, for example, in very risky business lines, or those firms where creditors have very low information. So this seems to suggest that those firms really need to have this additional bond, this additional promise, because they are more risky than others. But this is definitely something where more research can be done. So summing this all up and trying to connect back to the excellent paper, I think we can take those thoughts as inspiring future research in this field, right? So it would be very interesting to benchmark those provisions from the IBC 2016 towards those economic principles. And we've heard that the IBC has sort of empowered security and secure credit to a certain extent, but there are some gaps that still remain. And please bear in mind that we shouldn't overdo it, right? So try to get that line, that fine line, the balance right between private ordering and setting limits so that the secured creditors cannot completely exploit the creditor. Also, what's important, and maybe something to think about for the future, is what about the impact of the creditor structure? So depending on how strong creditors are typically in a given country, you need very different legal instruments. So if, for example, you have a very concentrated banking sector in a particular jurisdiction, very strong, powerful banks, then the law doesn't probably need to support them a lot, right? Because they are very powerful in negotiating anyhow. In a country with a very weak and dispersed banking sector, the law much more needs to step in and to give them force in the bargaining process to facilitate security. And finally, it would be interesting to verify those empirical studies that I mentioned, right? Because most of the studies that I cited were done in Europe and the US, and it would be very interesting to see how they stand up or not in the Indian context. Final thought that I have, what is the implication of the legal change? So it would be very interesting to see how the provision of credit changed with the introduction of the IBC. Does it change anything in the provision of credit? Is it sort of more likely? Are the cost of credit going down because it's easier to take credit under the IBC, for example? That would be very interesting to study. So in that spirit, let me just leave it there and think, these are all fantastic, good reasons to do more exciting research in insolvency law in India. And I'm very excited about this launch event and congratulate everybody on this exciting project, which I think will help us to enlighten those questions. Thanks very much. And everybody have a great session today and tomorrow.
Thank you, Georg. A bit of a deja vu back to your classroom on the points of ex ante and transaction costs, but all good memories. On the note of, on that particular background of insightful international and theory of law and economics, let me invite our next discussant, Sagar Shankar, to provide his thoughts on the paper and respond to Suharsh.
Thanks a lot, Ishana. I hope I'm audible and clear.
All good.
Yeah.
Okay, great. So I just wanted to, first of all, start by thanking you, the Dean, Professor Gupta, and the JGILS Global Law School for extending an invitation to be a part of this seminar series. I wanted to start with two short disclaimers. The first is that, unlike most of the participants here, I am not a lawyer. So my interest in insolvency and creditor rights and secure transactions, it really comes from the objective of increasing access to finance for SMEs, and particularly on how information technology and system-based innovations can help in this. The second disclaimer is that the views and comments that I share here today are my own, and that they do not represent the views, the recommendations, or the policies of the World Bank Group, the senior management, executive directors, and the countries that they represent. So with that out of the way, I really want to commend the authors, Suharsh and Gauzia, as well as Urmika, on this really interesting paper, which has mapped the evolution of secured creditors and their rights in the IBC over the past 5 years and the jurisprudence around that. I think that the paper rightly identifies that the risk appetite of secured creditors is really dependent on the value of the security, the ease, and more importantly, the certainty of enforcement of these security interests. And these form some of the cornerstones of the World Bank Group's principles on effective insolvency and creditor rights systems, which is that jurisdictions should strive to provide a transparent procedure that contains and consistently applies clear risk allocation rules, as well as incentives for gathering and dispensing information, and that they should recognize existing creditor rights and respect the priority of claims with a predictable and established process. So what this necessarily requires then is that there has to be a robust foundation for information on secured assets, the charges created on them, and the ranking of creditors who have created these charges. This continues to be a gray area in India, and in my opinion, is a constraint on the speedy resolution of insolvency cases, as well as of those cases that proceed into liquidation in the country. This is an issue which the authors have recognized in the paper. They've cited the Supreme Court judgment on SR, which emphasized that secured creditors need to be accorded some form of priority in the restructuring process. Otherwise, they're more likely to vote for liquidation, as that would generate better returns for them. The issue which I aim to speak a little bit about here today, and which I hope the authors as well as the other participants of this seminar will examine in future research, is the multiplicity of registration systems, registration requirements, and the quality of information on security interests that is available in India. Just as a broad overview, we have the registrar of companies for charges created on assets of a company. We have the Indian Collateral Registry SARSAI, which registers charges created on immovable and movable assets under the SARFAESI Act. We have the information utilities under the IBC to register the interests of both operational as well as financial creditors. And then finally, we have the large number of registries that are operated by individual states primarily for registration of mortgages. So even today, in 2021, it remains an uphill task for insolvency professionals, for creditors, and for their advisors to glean the necessary information that's required to determine the liabilities of the firm, determine the ranking of priorities amongst creditors, especially secured creditors, and to get a clear picture of the lay of the land with regards to the insolvent firm. I'm not going to get into much detail about the larger issue of ease of doing business that is created with this kind of an ecosystem, where you have multiple registration requirements, fees, and time, which is being spent on registering, in most cases, the same security interest, multiple registries. So this is definitely an area where additional innovation in both systems as well as in legislation is required, I believe. There was one attempt that, as part of a project that I was involved in, that we made. This was the SARFAESI Amendment Act of 2016, where we actually recommended that the Central Collateral Registry, SARSAI, in a sense, becomes the gateway to all registration systems in the country, and access a single portal through which any person with interest in an asset, whether it be a prospective creditor, prospective buyer of that asset, can go and quickly search and find out the details or security interest that might be there on that asset. Unfortunately, it's been 5 years, and that recommendation is still to see implementation. But I hope that's something that will be taken up by the government at some point in the future. The other area that I want to touch upon, which is the second interesting aspect of the paper, is about intercreditor agreements. I'm not going to get into the analysis which has already been done by the authors, with which I agree. But I want to talk a bit about the issue around the certainty of ICAs and the sanctity of ICAs in the Indian financial system. For the past couple of years, bodies like the Indian Banks Association and also moral suasion by the Reserve Bank of India has been directed towards creating a standard for these kind of intercreditor agreements and for ensuring that there is some level of enforcement as well as sanctity to them. But this continues to remain an area where work is required, based on discussions that I've had with insolvency professionals as well as with bankers. There needs to be clear guidelines around these ICAs, and there needs to be possibly model ICAs that are created that can be followed by creditors. And this is really important, in my opinion, to ensure that creditors are encouraged as far as possible to adopt out-of-court workouts and out-of-court restructuring as the first port of call instead of coming to the IBC, primarily to ensure that the resolution of the firm, the insolvent firm, is carried out as swiftly as possible, and that the economic value of the firm is preserved to the extent that's possible. And I hope that this issue is one that will be examined in the various responses that I'm sure insolvency professionals, lawyers such as Suharsh and Gausia and Urmika will submit to the IPPI and their recent discussion paper on the development of a code of conduct for the COC. So I just wanted to share these thoughts on where I believe information can play a much greater role in improving the efficiency of the insolvency resolution process in India right now. And I'd like to close by again thanking the JGILS Global Law School for this important initiative. I hope that this spurs further research and analysis on the IBC. And I completely second the recommendation made by Georg about the need for more empirical research on whether the IBC has actually resulted in not just greater returns to creditors from companies that have gone insolvent, but whether debtors are seeing benefits in terms of better terms of credit, better interest rates, etc. So those are my thoughts on the paper, and again want to congratulate the authors for the interesting paper that they put out. Thanks.
Thanks a lot for that, Sagar. Very different policy perspective there. Before I ask the standard moderator questions, I wanted to check if Suharsh wanted to respond to Georg and Sagar, and if you have any thoughts on the comments that they've made on the paper.
Thank you, Shana. So, I'll start with George's comment. So, George, thank you. It's a very interesting perspective of how you do have a bleeding heart for unsecured creditors, which goes against the tide of how things are currently in India. And I just want to briefly comment on that. And there's the reason for that. I think, as I mentioned very briefly in the presentation as well, is tied to one of the bullet points in your presentation, in fact, that we have a very concentrated banking system. Not only is the banking system very concentrated, it is owned by the government. So I think 80% of the loans dispersed, if I remember correctly, are by government banks. And amongst government banks, there is one bank, which is the State Bank of India, which is larger than all the other government banks combined. Right? And the non-performing asset ratio in the country when IBC was enacted was more than 10 to 12%. And now it's likely to touch 15%. And lastly, almost all of bank lending in India, a huge proportion of it tends to be secured lending. So I think the problem being solved through the bankruptcy code was not merely restructuring of firms, but also protection of the government banking sector. So they're trying to solve another problem altogether through the IBC. And just one more comment I'll make on that point is that I recall when I studied US bankruptcy law that there were huge trusts set up due to asbestos litigation in the context of US bankruptcy law. Now, that unfortunately is something which may not be feasible in the Indian context. And I think from a policy perspective, that is worrying, because in case there is a large environmental or tort action, which requires a huge payout from the company or from any incoming bidder, that gets subordinated and whitewashed under the Indian bankruptcy process. So I think from a policy perspective, it is slightly worrisome that the public good or pollution or mass tort events can effectively get extinguished and whitewashed under the bankruptcy process. So I do feel there's some scope for rethink on the policy front.
Interesting, thanks. Yeah.
And on Sagar's comments, thanks again, Sagar. I think that was very interesting. I'll just make a couple of comments. So on whether empirically creditor rights have been strengthened, and as a result of that, whether the cost of credit has gone down or not. I think that's certainly a very interesting and topical area of research. Given how our economy has been in the past few years, I think at least the public sector banks, they gauge interest rates more on the basis of monetary policy as opposed to microprudential policy on how an individual lender and borrower is. Which again, I think is a product of the lenders not being able to think for themselves. A lot of the lending and a lot of the interest rates are led by the Reserve Bank of India and is policy led, as opposed to on the financials or the cash flow projections of individual borrowers. So I think that link will be difficult to establish, not because empirically it's difficult, but because it'll be very difficult to separate out the two as to how much of it is because of IBC and how much of it is linked to the policy rates set by the RBI. And sorry, there's one more point which I had in mind, but sorry, I can't quite recall, but I'll come back to it if I didn't recall, Sagar. My apologies.
So thanks for that, Suharsh. Now, I just want to highlight on the fact that this is a very topical issue and obviously is being discussed at a legislative and regulatory level as well, with the discussion papers, one of which Sagar mentioned in his presentation, being as recent as August 27th. Now, one question there and one recommendation there is in relation to the enforcement of security interests and the rights of secured creditors during liquidation. And one aspect that I feel is needs to be considered is the enforcement of security interests and its considerations during insolvency resolution as well. Georg took us through the pari passu principle there and the recovery. So I find it quite strange that we have not really looked at what will happen to monies that a secured creditor will recover as a part of insolvency resolution or liquidation when he is enforcing his security interest outside the insolvency resolution process. So any thoughts on that, Suharsh, and also the rest of the panel if they want to weigh in on it, because it seems to be an important reform, and as we understand, it is the backbone of the lending market right now, which is secured credit.
So thanks, Ishana. So, during the CIRP process, secured creditors will not be able to enforce their rights. And I think that is one of the objectives of any insolvency law, that there is no piecemeal enforcement of assets, because that means that, there is no effective possibility of a revival of the company. If certain lenders pick up key assets of the company for individual enforcement. But outside of CIRP, once the company goes into the liquidation process, then of course lenders are free to enforce their individual security interests. And let's also look at a scenario which is pre-IBC, so before the company goes into insolvency. I think there's huge scope for improvement when it comes to creditor rights pre-insolvency, because the tools that creditors have today, and I'll just give a 30-second background to George, because he may not be familiar, is that the civil courts in India have proven to be not a very effective forum for enforcing creditor rights, because they're plagued with massive delays, appeals, and so on. So the government came out with a very specific law for banks and financial institutions to enforce their security outside of court. And that's called the SARFACI Act. It's got a huge, SARFACI is an abbreviation. So the idea was that lenders could just have auctions, public auctions, and take on property without having to go to a civil court for enforcing a decree of enforcement. There have been many gaps in the SARFACI law. That could be the subject of another discussion altogether, but I think there's huge scope for improvement in the SARFACI law, because even though it is an out-of-court process, borrowers, through various decisions of courts, have found a wriggle room to be able to even object to out-of-court enforcement through SARFACI. So I think that there is scope for improvement on that
front. Can I just quickly say something? So this is super interesting, and all the more sort of reconfirm what I said earlier, that it might be really interesting to rethink some of the European/American conventional wisdom that we have on insolvency. Of course, it's not one-to-one the same, because as you rightly pointed out, the court system works maybe completely differently, and therefore there's even more justification to have out-of-court enforcement, right? Which points even more to empowering the security interests out of court. If the court procedure itself takes forever, which is another additional element that would support that reform, right? And what you said earlier about the structure of the banking sector and the government behind most of the loans, essentially, which is really interesting, which could be interpreted as something, the government is self-serving itself by facilitating credit. Right? But you could ask the question, is that really necessary? Because the government will be negotiating probably very toughly anyhow, and will be able to protect itself. So maybe arguably doesn't need that same strength of the law as any normal ordinary creditor would do. So, again, no legal discourse can be transplanted as it is 100% into another jurisdiction. It always needs the experts to really work out the details. But so thanks for letting me know all of this.
Thank you.
So the second sort of question that arises also from the paper is the aspect of dissenting creditors. We also have an audience question on the aspect of dissenting creditors and how resolution plans are essentially imposed on these dissenting creditors. What's the perspective there from a secured creditor standpoint, where despite the fact that you have secured credit, if you're a dissenting creditor to a resolution plan, you are just crammed down? Any thoughts on that, Suharsh?
Sure. So I think there is an element of fairness built into the law, that you cannot extinguish a secured creditor's rights by cramming it down, by saying that, so the threshold under Indian law is 66% of the COC. So by a 90% or 95% vote, you cannot take away the rights of the 5%. And what do we mean by the rights of the 5%? I think that is more important. It's nothing but creditor democracy. It's not only majority rule, but it's also minority protection. And when it comes to minority protection for creditor rights, it means that the creditor's security value or the collateral, the commercial bargain which the creditor had struck when it gave the loan, that is sacrosanct. That is a threshold which cannot be breached, right? So you must get at least the value of the security. That's enshrined in the law now. It was upheld by the SR judgment. But unfortunately, the latest judgment which I spoke about, that kind of erodes it by equating secure creditors in one bucket, instead of appreciating that certain creditors may have an exclusive charge over a certain piece of security because they were more prudent, or they came early on, or they are charging a lower interest rate, for whatever reason. And that bargain being discounted by Supreme Court, I think, is worrying.
Any thoughts on that question, Georg or Sagar? Or shall I open up to the audience? All right, we take some audience questions. We have an interesting question from Sriram, and this is to the authors. He cites the case of Technology Development Board versus Anil Goel, and says that the judgment says that the CIDCO judgment and the SR judgment has been eroded because you're not respecting interstate priorities of secured creditor in liquidation and waterfall. What are your thoughts on that judgment, if there are any specific thoughts based on that case?
So, sorry, Sriram, I may not have read the Anil Goel judgment, but I've read the CIDCO judgment. And again, for the benefit of other panelists, there is a judgment which basically says that the priority of charge must be respected in liquidation. And before the IBC came along, this concept emanated from the Transfer of Property Act, which basically said that if there are 2 or 3 mortgagees on the same piece of property, and the property is liquidated, you satisfy the first one completely, then you come to the second, then you come to the third, which is respecting the priority of charge. And that's basically what the CIDCO judgment said. If that has indeed been eroded by the Anil Goel judgment, then it is indeed worrying. And I think where it may have come from is because there is a clause in section 53, which is the liquidation waterfall, which says that the liquidator is entitled to disregard any agreements which may be there among creditors who are at different levels for distribution of security or distribution of proceeds. The logic over there, I assume, may have been that the liquidator should not be burdened with figuring out the mechanics of inter-creditor agreements. The liquidator should just pay out on the basis of the strict priority set out under the code. And it's then for the individual banks or creditors to figure out the interstate distribution, either through dispute resolution or any other manner that they deem fit. That, I think, was the policy intent. But the way it is played out in practice is not ideal. And if we can tweak that section in section 53, the subsection in section 53, I think we can resolve this problem.
Thanks for that, Suharsh. We have a question on a general theory question, which perhaps even the other panelists can take a crack on from Shakti, where he asks whether the concentrated ownership pattern that influences the dynamics of a creditor-driven insolvency governance regime, which I assume is the ISC, and in the backdrop of an extensive emphasis on secured creditors, is there any interplay there? Is there any issue there?
So I think, George and I have discussed this at length, that India's insistence on superior rights to financial creditors, and in particular secured creditors, comes from a very particular socio-economic background, which cannot be ignored. And I think what the policymakers at that stage were also conscious of, and which I think it happens very often, especially in developing economies such as ours, is that we are very influenced by the World Bank ranking on ease of doing business. So I know for a fact, because I happen to be in some of those meetings, is that you literally took the checklist of the World Bank ease of doing business to see how you can get greater points for a revised Companies Act, a revised bankruptcy law, and that actually had very much greater points if you strengthen creditor rights and rights of banks and secured creditors. So that was an overarching objective for policymakers, not only the larger political and social reasons that I mentioned, but also making sure that this law appears to be an internationally sound law, which is acceptable to a global audience.
Yeah, I'd like to second that 100%. So I think there is one motivation that really interesting to study, right? To what extent you want to impress the World Bank. And the other audience you might want to impress are foreign fund managers, right? So particularly American fund managers, as countries are trying to be attractive to foreign investment, right? They frequently do legal reforms just to add things to the checklist that the foreign fund manager has, so what's the right of secured credits in that country, right? And then they can tick it and say, okay, yes, I make the investment. And these reforms, as you rightly pointed out, sometimes are dysfunctional, don't really make sense in a particular context which they operate in. So this is a fascinating question, I think, that really would be interesting to study. So what motivated those changes, right? And are they functional is the ultimate question.
Thank you for that. I do think that there's a lot of next working papers that have already been put forth. Yeah, I think I can already think of 10 to 15 papers, maybe chase down Suharsh, Gosia, and Ulmika for separate papers this time. But soft pitch. But I think just to sort of wind up, and I want to see if the panel and the author of the paper, one of the authors of the paper, agrees with me. I think three key focus points that we can take away is information, transparency, and how we sort of collate the material and related to secure credit and secure creditors. I know that information utilities play a huge role, but there's really been no offtake there. Information utilities being envisaged under the insolvency law as data repositories. The second aspect is definitely vis-a-vis inter se creditors and what are their rights, and should resolution plans provide for them, make them mandatory, or should there be private arrangements? There seems to be a lot of open-endedness in terms of inter se creditor agreements, and there might be a large scope for analysis of vis-a-vis inter se creditor agreements, because I know that they exist and they existed before the insolvency regime as well, but now we are obviously in a regulated M&A sort of setup, and therefore regulating inter se creditor agreements as well. And the third most, I think, important takeaway, which should be written about from a law and economics perspective, is what is the actual impact of the way secure creditors, which have supremacy and have been given importance in the lending market as well, their resolution in the insolvency process, and what is the subsequent impact of what they are recovering or what is being resolved as a part of the insolvency resolution or even liquidation. So I think those are the three takeaways, at least for me, and I will let go around the table and allow for parting thoughts from each one of you, and then close, I think, what has been one of the a brilliant start to the show. We'll go with Suharsh first.
Thank you, Shannon. I think this was a very lively and very interesting discussion. Many thanks to you and to Georg and Sagar. I think I learned a lot. I think what tends to happen as a practitioner is that you're so steeped in the everyday practice of law and transactions that at times you fail to realize the larger policy implications and the larger policy underpinnings of why law is the way it is. So very refreshing to have spoken to this distinguished panel. Thank you so much for the opportunity. And as you said, some very interesting thoughts that you left me with. And hopefully we can collaborate again in the future.
Thanks also from me. I think this couldn't have been a better start for this launch event of wonderful discussion. And I think it shows how important this, not just the interdisciplinary research, but also the international discourse on those things is, right? So understanding each other and just understanding legal structures and rules and context is of paramount importance. And one argument that works in one country doesn't necessarily work in the other one. So we need more of that type of dialogue, I guess. And this is the spirit in which this working paper series operates. So a wonderful opportunity, I think. Thank you.
I just want to echo what Suharsh and Georg have already said. Thanks a lot, Ishana, for putting all of this together. On your three takeaways, I just want to add one additional point, which I hope will be taken up by researchers in the future, is about whether IBC in its 5 years has actually expanded access to credit, and especially for firms at the lower end of the market, SMEs, startups, and individuals. So I hope that's an area that will be plumbed for more insight and more empirical research. So that's it. Thanks a lot again.
Thank you, Sagar. Thank you, panel. Thank you, everyone who's listened to us on YouTube and everyone who joined via Zoom. We had a fantastic start with Mahesh and a fantastic close of day one. I hope to see most of you tomorrow for the other 3 papers that are part of the set. You can download the papers in the link that I've circulated. And thank you very much for your support for this excellent launch. Thank you, everyone.
Ishana, I'll just take 10 seconds, sorry, to thank Gausia and Urmika as well, because they have been very strong yet silent participants in this endeavor, without whose contribution this would not have been possible. So many thanks to both of them.
Of course, you're going to hear from both of them tomorrow. To the attendees, wouldn't let them go without getting another paper in. So thank you. And
thank you.
See you all hopefully tomorrow. Good evening, everyone.
Thank you.
Thank you. Bye.
Thank you. Bye-bye.